Hi, my name is David Fraser. I'm a privacy, internet, and technology lawyer with the Canadian law firm McGuinness Cooper. I also teach internet and media law at the Schulich School of Law at Dalhousie University. A short time ago, I was speaking at a labor and employment law conference, not surprisingly on the topic of privacy. We ended up having a very interesting discussion about the growing practice of employees secretly recording conversations, sometimes conversations that they are a part of, and in other cases that they are not. Because just about everybody in the room had something to say on the topic and a story to tell, it seems clear that this topic might be of a broader interest. So, workplace recording by employees. Is it illegal? Probably not. Is it hostile and problematic? Certainly. Now, can employers put in place policies to prohibit or at least regulate the practice? Absolutely. Let's start with a basic primer of the laws applicable in such a situation. The most serious law potentially involved is the Criminal Code of Canada, which makes it a criminal offense to record a conversation that you are not a party to, and where there may be a reasonable expectation of privacy. This is sometimes called one-party consent. Essentially, it is a crime to intercept a private communication or conversation without the consent of at least one party to the communication or conversation. For example, it would be a crime for an employee to leave their smartphone in a room with the audio recording on, and then leaving the room without telling the other people in that room that their conversations would be recorded. Mostly what I'm hearing about is employees secretly recording conversations that they are having with colleagues in the organization or their supervisors. Because they are lawfully a part of the conversation, they are not intercepting a private communication, and the Criminal Code of Canada is probably not triggered. But that doesn't make it okay, though. Some workplaces are subject to federal or provincial privacy laws, and these laws generally regulate what the employer can collect, use, or disclose. If that workplace is subject to those laws, the boss recording a subordinate would trigger those laws, and at least notice would need to be given to the employee. An employee recording an interaction with a customer would be subject to the privacy law, which would trigger the requirement to give notice of the recording and to get consent from the customer. But an employee recording for their own personal purposes would not be subject to privacy legislation because they are not themselves an organization under those laws. But that doesn't make it okay. The practice of recording conversations, particularly if it's done secretly, is generally perceived as an inherently hostile act. The person is looking for the gotcha, or to use it against the other person in the future. Employers have the right to regulate practices such as this as they affect the workplace and the relationships between employees. There are other environments where recording may not be illegal, but it can be problematic. I've advised hospitals and health authorities about policies governing audio and video recordings by patients. Sometimes physicians and others see recording as a hostile act and want it prohibited. I've spoken to psychiatrists and psychologists who say that patients sometimes want to record their therapy sessions. Again, this is sometimes seen by the practitioner as a hostile act. In a hospital or other semi-public setting, there are also the privacy interests of third parties to consider. That said, I'm not sure recording is always a hostile act or something to be very concerned about. I remember when my father was diagnosed with cancer and was then going through treatment. At every doctor's visit, my mother took copious notes of everything that was said. It wasn't to accuse the doctor of anything later, but because it was such a stressful moment, she didn't want to forget anything. It was so much all at once. All of it was very important to get right, and if she had a smartphone, I probably would have suggested recording the doctor's advice, with the knowledge and okay of the doctor. I once spoke with a psychologist who was concerned about a patient who wanted to record their sessions. I asked him, "How does that make you feel?" He said he felt apprehension and unease. When we explored it further, it was clear to me that the patient actually benefited from listening to the session over again. It helped the therapeutic relationship. Insights from the session were reinforced, helping the patient. And I suggested to the psychologist that he not object to the recording, but to caution the patient to take very good safeguards to protect the recordings, since they obviously contained very sensitive information. Now, if a psychologist wanted to record a session for their own record-keeping purposes, they'd have to let the patient know. There are other completely legitimate reasons to record a conversation or a meeting. You may want to have a good record of what was said and by whom. You may have an employee with memory or retention issues, and recording may actually be a form of accommodation for a disability. You may just want to leverage automatic transcription features. The important thing is to have a policy about the practice and generally be nice people. In this day and age, organizations should have a policy about audio or video recording in the workplace by employees. It would vary according to the particular workplace, but I'd suggest starting with the following principles. First, any decisions about recording customer interactions can only be made by management with a full review of the privacy implications and compliance requirements. Secondly, there should be no recording of colleagues without letting everyone involved know that the recording is taking place and why the recording is being made. Third, people who object to the recording should be able to make their objection known, and this should be taken into account. And fourth, anyone who is recorded with consent should be able to get a copy of the recording. Finally, any recording should be treated as a business record and managed accordingly. It can be very problematic having such recordings hanging around, lingering on personal devices. Now, if you have a clear policy and everyone is aware of the policy, you can enforce it and back it up with discipline, just like any other policy. And if you don't have a policy, you run the risk of having difficulty taking action when this happens. So at the end of the day, recording of employees by other employees is generally not illegal as long as it's not eavesdropping. But it can be problematic in the workplace, coming across as hostile, causing issues. So employers would be well advised to think about having a policy that works for their workplace and making it known and enforcing it. I hope this has been interesting and useful. I try to put out a new video every few weeks, so if you're interested in this sort of content, please click the like and subscribe buttons. Also, leave a comment if you have any questions or if you have any suggestions for other topics to cover. And of course, feel free to share this with anyone you think may be interested in hearing about Canadian tech and privacy law. Thanks for tuning in.